George Zimmerman's father is telling his son's version of the events on the night that Trayvon Martin was shot and killed, and he did so on Fox News last night. Have a look.
He was walking back to his vehicle. Trayvon came from his left side, asked him, did he have a problem? George said no. At that point, Trayvon said, what do you do now? He punched him in the nose, again, knocked him to the concrete, and started beating him. George was there yelling for help for at least 40 seconds. It's clearly him on the tape.
And Zimmerman's father was appearing in silhouette, Lou Palumbo, because he's worried about his safety. He says that they've had death threats. Lou Palumbo is a retired Nassau County, New York police officer and the director of Elite Intelligence and Protection Agency. I always am very disturbed in a story when I see someone who fears for his life because of something that hasn't even ended up in a courtroom yet. But that's the story here. He's too afraid to show his face because he's very concerned for his safety. But he did say one thing that's new, that his son yelled for help for 40 seconds before anybody came to his aid. Does this change the equation at all in what has become a national dialogue about what happened that night?
No, it really doesn't, because the bottom line is that he used excessive force. If this was just simply a mugging, let's say that's for purpose of analogy, and the perpetrator of that crime was unarmed, that would never justify you in using deadly physical force to repel the attack. Your option would have been to run or retreat. And I don't want to delve into this whole issue about stand your ground, because
But it is an issue, because in Florida you don't have the duty to retreat.
But experts who are very well versed in this law have already determined it doesn't apply here. And I think we need to go back and really start to examine that law and understand the situations it could precipitate.
Let me ask you this. I wasn't there. I didn't witness it. You weren't there. You didn't witness it. All we have are competing suggestions of fact from those who are family members of those who are involved, which you can't state as fact. Those are accounts. They're hearsay at this point. But one of the accounts that has been leveled, and this comes from George Zimmerman's camp, is that there may have been a moment where the gun became visible in George Zimmerman's belt. And if, and I am suggesting only if, because again, I don't know what happened, but if it's possible that George Zimmerman thought Trayvon was going for his gun, if Trayvon might have been going for his gun, fearing his life as well, does that not then absolutely justify a stand your ground for both of these two?
Yes, I think if we were going to entertain the stand your ground, it probably would apply to the both of them. But I do want to point out something on the heels of the comment you just made to me about the visibility of this weapon. Mm-hmm. It was Mr. Zimmerman's responsibility to keep that weapon secreted. That's why we call it a concealed weapons permit. If you place it on your body where it's readily visible, that's your problem that you precipitated. The whole exercise in carrying a concealed weapon.
Is a concealed weapon on my side covered by my jacket?
It should be, yeah.
If I fall over and my jacket opens up and then it's visible, is that no longer a concealed weapon, and is that your fault?
No, it's still a concealed weapon, but you know, I'd have to further examine the garments that were worn by Zimmerman, which we already know.
A loose jacket.
Understood. Maybe what he needed to do was have it zippered to make sure it didn't open.
So here's the other question when it comes to carrying a gun. There's been a lot of discussion about whether a neighborhood watchman should be carrying a gun, and if the organization says no, this is not the kind of job for an armed patrol. But Zimmerman's camp says he was on his way to Target. He wasn't on patrol, but that he spotted something he may have thought was suspicious. That's up for debate as well. But that is he then required to get out of his car and put that gun in the trunk and secure it so that he can go and check something out on the lawn of one of his neighbors?
In theory, what he could have done is exactly that. He could have taken
Could have, but is he required to?
I would say under these circumstances, yes. But he's already established for us in a 911 call that he was...
But he's licensed to carry a concealed weapon.
Not in this capacity.
Again, he's not in a capacity. I'm just playing the devil's advocate because the devil is in the details on this one.
The bottom line is that he made a 911 call and he volunteered for us the fact that he was following him. That put him in the capacity right there, his overt act of following him. At that point, he should have unloaded that weapon and safeguarded it in his vehicle if he thought there was any chance whatsoever that he might need to encounter Trayvon Martin.
Are you saying morally or legally?
Both.
If you have a concealed permit, license to carry, at what point does a law kick in that says you must put it away to go and seek someone out to see if there's something wrong that's happening?
I'll explain that to you. In the state of Florida, you may be in possession of a concealed weapon, for example, But in order to carry that weapon concealed in a work-type environment or capacity, it's a separate licensing process and acknowledgement.
Capacity.
Exactly
But
correct.
again, if he's not in a work capacity.
But he put himself in a work capacity. When we're off-duty law enforcement agents, the minute we see a bank robbery go down and we decide it's necessary to take action because there's imminent danger to people, we go on the clock.
All right.
And the same thing applies to him. And I know that he may not have had that presence of mind to understand that. That's all why we need a little more education for people that are carrying concealed weapons other than just randomly giving them guns.
Let me jump into another new development in the case, and that's this voice stress test that came out yesterday. It's been now made clear by George Zimmerman's attorney that the police in Sanford, Florida administered a voice stress test, which I had not heard of prior to this, and I've covered a lot of court cases. Of course, it's not the kind of evidence that comes in as evidence in a court of law, but it is, as I understand it, the same kind of tool as a polygraph test.
Well, let's be fair about this. First of all, it doesn't have the same regulation as polygraph examiners have, or the examination itself. It's relatively recent, over the past few years. Simply stated, what the test is an analysis of the stress in your voice. Your voice has muscles. Tremors take place, and they attempt through examination of those tremors
to determine. See if you're being truthful, right?
To see if you're truthful. The test is valueless. It's inadmissible in court.
As are the polys.
As are polygraph exams. To me, it's dangerous from the standpoint of an attorney to allow any client to take an exam that can only harm him. They can't go into court and say, I took a VSA.
But to our knowledge, at this point, George Zimmerman never asked for an attorney, never called for an attorney, and did this on his own without an attorney present.
Well, this is a man that's been around the law enforcement environment for quite some time. He should know about the Miranda rights and your Miranda warning.
If he got them.
Well, again, you're right about that. I mean, and the bottom line is, were the police even required to give them to him? You know,
we could go on for an hour on this.
Every time you pop me with something, I'm going to give you an explanation.
Yeah.
You're only required to give somebody Miranda warning and Mirandize them if you're going to interrogate him. In other words, if I take you off the street...
Well, there's some issue about that as well. If you're put into custody, if you're in cuffs, there have been a lot of arguments. Casey Anthony case in particular was a big issue because Casey Anthony was in the back of a cruiser and was in cuffs, and then she wasn't Mirandized.
Every case stands on its own merit.
Yeah.
If you voluntarily get in the vehicle and in the process of transporting you to a police precinct, you start to speak, I haven't Mirandized you, it's admissible.
Yeah. Like I said, I could go on for an hour, but I'm getting the hard rap because we've already talked so long. Thanks so much for coming in. It's always good to talk to you. Lou Palumbo joining us. Zaretta.